Slide number 2. Now, as a general rule, there are no proprietary rights in sports events. No proprietary rights in sports events under common law. And there are English cases as well as Australian cases and other common law cases providing such authority, right? But then you can get access to the sporting event with your tickets. And access rights include ticketing rights and broadcasting. However, if you're organizers, you can do one thing. You can do one thing, that is to have restrictions printed at the back of your purchase ticket. And that will be effective enforcement of the law of contract. Or you can, for example, not to allow photographic equipment to the venue. Other restrictions include zero form of advertising devices or giveaways. You cannot bring items to giveaways during a sports event. Now, the tickets sold, do not forget, remain the property of the event organizer. The tickets condition must be brought to the attention of the purchasers. So the best thing to do is that to have the restrictions printed at the back of the tickets and also at the entrance to the sports venue. So, as a general law, no proprietary rights in sports events. Slide number 3. I mentioned again and again, no proprietary rights in a sports event per se, meaning that you cannot enforce legal rights. Very interesting. But however, in sport marketing, they always refer to some rights, like sports event image rights of the athletes, broadcasting right, sponsorship endorsement, official supplier rights, merchandising and licensing rights. That is okay. But the English law and the law of the common law jurisdiction does not recognize a sporting audience, sporting event, sporting spectacle as a dramatic work in which there is copyright. I re-emphasize again, no proprietary rights in a sports event whatsoever. Slide number 4. Now I am going to bring you to a very interesting case called the Sports and General Press Agency versus Our Dogs Publishing Company Limited. And this is in English called the decisions. What are the legal issues? I will mention it. Whether the plaintiff photographic agency, whether in a sports event, has exclusive rights to take photographs at a dog show. Now, in this case here, it's very interesting, right? It's called the Sports and General Press Agency versus Our Dogs Publishing Company Limited. Now, this is a ladies' kennel association. In other words, associations owned by lady dog owners. Right? They had a dog show. And then they give exclusive rights to an independent photographer, to a photographic agency, to take exclusive rights. In other words, the association enter into contract. And that contract provided the specific photographic agency the exclusive rights to take photographs at the show run by the association. What happens? An independent cameraman came. He took photographs and he sold it to a publisher for a profit. Then the association sued him and the publisher. The independent contract cameraman came to the dog show, took photographs, sold the photographs to a publishing house. The association sued the publishing house. It was unsuccessful. Why? Why was that? Because the publisher pointed out rightly there was no prohibition on photographing an event, nor had anyone imposed such prohibitions when granting admissions to the show event. Now, Lord Justice Eddy in the Court of Appeal had this to say, I quote, okay? Excluding those they did not, and that right carried with it the right of laying down condition binding on the parties admitted. It might be a condition that they should not bring cameras to take photographs or to make sketches, but they did not lay down such conditions, right? Therefore, an independent cameraman could enter the event to take photographs. What they ought to do was to have restriction on anyone coming to the event not to bring in camera, video camera, or video, right? And also state clearly that no photographic activities would be allowed, but such restrictions did not exist. Therefore, the associations did not succeed in that case. Slide number 5, please. There's another very interesting case for the Victoria Park Racing versus Taylor. And this is actually an Australian High Court case. Here, in a very simple manner, the defendant had not infringed any recognizable rights belonging to the plaintiff. Right? The plaintiff operated a race course. You know, horse racing is still very popular in Australia, in England, in Singapore, and in Canada. Now, discuss in case in relation to commentary of the by the defendant for radio broadcast. But what happened in this case here? Here, the defendant actually owned a residential property next to the race course. His house was next to the race course. So what did he do? He erected a scaffolding tower on his front lawns that overlook all the high barbed fences behind the race course and enabled him to produce a commentary of the races then broadcast live on radio. Isn't that interesting? The plaintiff, in that case, operated and owned a horse racing stadium and tracks. One person erected a high tower that he could take pictures of all the races and then make commentary and show it to a radio station. Now what happened? The Australian High Court again rejected the claim that the defendant actually had not infringed any recognizable rights belonging to the plaintiff. The first case was a dog show. This case was a horse racing show. No proprietary rights whatsoever. Now, let me quote to you. In this case here, the mere fact that damage results to the plaintiff from such a description cannot be relied upon as a cause of action. Audience, the events cannot be owned in the ordinary sense of the words. So this, in a nutshell, is no proprietary rights whatsoever in any sports event under English law, under Australian law, and I also believe under the law of most common law countries. Next, please. Now we will have something very interesting. It's called BBC Talk Sports. BBC Talk Sports is a case that's something to do with the broadcast commentary of Euro 2000 matches, right? Now, Euro 2000 matches were viewed worldwide, right? Now, question here, whether BBC had the exclusive rights. Now, the next case, please. The next case is very interesting. Douglas versus Hello. Douglas versus Hello. Hello is a magazine, you know. Now, this is a case reported in 2007. This involved two prominent movie stars. Right? It is an OK magazine, and they brought this action against Hello magazine for destroying its exclusive rights to the wedding pictures of two movie stars. Right? Now, one of them is Catherine Zeta-Jones. In fact, when I was giving a lecture at the University of Wales in Swansea, the dean told me she was accepted into law school in the University of Wales in Swansea. At the same time, she then had an offer for a movie role by Hollywood. She did not know what to do. So the dean said, be a movie star and come back to law school later. But my reply was this, she would not come back.
Okay.
Do you know the difference? Because a wedding event, right, is not a sports event. That's the difference, you see? I mean, a wedding reception is not a sports event. Then that is why you have successful legal recourse. It's not a sports event, even though in this case here, the wedding involved two prominent movie stars. So, next slide, please. Now we talk about ambush marketing. Ambush marketing. What is ambush marketing? Something not solicited. It is always associated with the business, someone coming to the sports venue with its name, its products and services relating to the sports event. And they're trying to benefit the organizer's goodwill without having to pay any right or any contractual rights for this privilege. Ambush marketing is usually undertaken by the competitors of the official partners of the organizers. They usually make use of legal loopholes, apparent loopholes. Now, ambush marketing, remember, is associated not only with sports event, but other entertainment events as well. Slide number 9. Let me define the real objective of the ambusher's objective. What are they trying to achieve? Now, ambush marketing is definitely a commercial threat to the ability of the organizers to get money, to get full commercial revenue for the goodwill generated. Now, the objective was to demonstrate ambush people, to demonstrate to consumers that the ambushers' products or services are endorsed, sanctioned, or even authorized by the organizers, or they associated with the sport event, and without having to pay a single cent for getting this privilege. So this, in a nutshell, is known as ambush marketing. Like, for example, when I went to a race course, sometimes I will be given some free products from strangers, and I know that this is part of ambush marketing. And there is an element of criminality too. And usually the security guards and the security police will definitely arrest such people because they're trying to get benefit, the commercial value or the goodwill, without having to pay for it. Slide number 10. Now, what are the examples of ambush marketing? I listed out 5 items. Like, for example, you get free packages, really free packages of photographs, items. Then you can get unofficial publication, merchandise, and big screens advertisement, sometimes in a car parks. Now, unofficial publications are very, very common with horse racing. You have the official publications and the unofficial publications, right? And sometimes these days has become more sophisticated. They even created websites. They can also promote this on their website. And what do? They can organize the competitions and give free tickets as prizes in the promotional competitions. Just imagine, people will be attracted by the free tickets and they will participate in the promotional competitions. But do they realize that they are being taken advantage of by the ambush marketing people? And the other things are banners and advertisements. So these are the 5 examples of ambush marketing. Number 11. Now we talk about access rights. What access rights? Now, organizers, they pay a lot of money. They should have control over who are the people that can enter the sports event, right? The main purpose is to generate revenue for the organizers. It's an expensive thing to organize a sports event, be it horse racing or soccer. Their main sources of revenue are selling tickets and broadcasting rights. These are the two main sources for the organizers. Now, the real property law does provide ownership, leasehold, or license of the land. Okay? The venue, we can protect the owners under real estate, real property law. Okay? Now, what are the relevant legal authorities, the relevant laws? You have to go under the law of contract and the law of tort. Tort, for example, you can have an action on the grounds of nuisance and also against trespasses. So these are covered by the legal principles under the law of contracts and the law of tort. In a nutshell, access rights. Slide number 12. Now, let me go back to proprietary rights in sports events. Broadcasting rights. Now, rights include access to the venue, record the movie, the activities, and to relay the news and footage. You can enter into a binding contract with a broadcaster. Then, licensed cameramen, photographers, journalists can only use images and text from the matches subject to specific barriers, specific restriction. Then services such as data analysis and gambling are prohibited. In my early lecture, I did mention before the illegal revenue from soccer matches. Just in Europe itself, it's actually 0.5 trillion a year. And then you can see why I introduced sports law courses in Singapore, in India, and in China, is to generate an interest. Next, please. Then, when you have rights the sports event, then broadcasting rights, right? And the rights includes giving the owners of television stations to the venue to record and make videos of the activities to relate the news and the footage. Now, licensed photographers and journalists can only make use of images and text from matches subject to specific barriers. Next, please.
Excuse me, sir.
Yes.
I had a question about ambush marketing, if I may.
Could you ask this question at the end? So, please.
Thank you, sir.
Thank you so much. Do you have, I believe you're interested in this. I believe that in India you have ambush marketing too, right? I'm sure. It's a very big problem. Now, proprietary rights in sports events, there must be some control over the contestants and the athletes. These are legal challenges. I mentioned before, there must be clean and devoid of sponsorship and endorsement that conflict with the core promotional programs of the event organizer. There must be clean sponsorships. Now, the funny thing is that there was a company called Christine, and it was very famous at a press conference during the Atlanta Olympics for wearing the contact lenses that display Puma logo. Just imagine, just contact lenses. So that, why the contact lenses, when you take videos and camera pictures, then it's flash all over the world that Puma would be associated with that particular sport event. So UEFA actually fined a Danish player for flashing the brand of Petty Power. Can you imagine flashing the brand of Petty Power in his underwear in the Euro 2012 match? Isn't that interesting? Now we talk about proprietary rights, how we can enforce some legal rights in sports events. Now, at the London Summer Olympic, the stadiums before the Olympic game is called, let's say, XXX Stadium. But they have to cover up completely the stadiums. Any promotional activities must be organized, permitted by the sports organizers. And I remember in one of my lecture at the Beijing Olympics, which I attended, even the public telephone booths, they have to get the white sticker to cover up the name of the smartphone or public telephone provider. Things as simple as a public telephone booth, they have to cover it up. That is the meaning of having a very clean stadium, clean displays of public facilities. Next, please. Now we talk about intellectual property in sports events. Intellectual property, IP law. I believe that IP law is one of your legal subjects. In England, in Singapore, IP law is optional. Now, intellectual property rights and the law, the regulations do protect against unauthorized exploitations of the event commercially by third parties. Or unauthorized exploitations, then that will be a infringement, right? Now, what are the rights in IP law? One, copyright is very important. Trademarks, copyright. Then the database rights. The trademarks include register and unregistered. So these are some of the rights involving sports event. Copyright, trademarks. I believe that patent could also be included in today's usage of social media patents. Next, please. Now, copyright issues in sports events. Now, what are the copyright issues? Do they subsist in the ordinary, literary, dramatic, musical, artistic works, sound recordings, movie, films, broadcasts, and cable programs, and the typographical arrangement of published editions? And this is actually part of English law, which is covered under Section 1 of the Copyright Designs and Patents Act, known as CDPA. So, copyright issues in sports events. Next, please. Now, further discussions of copyrights in sports events. Now, the dramatic work that will have to cover activities like acting and dancing, like in if you watch the NBA match in North America, you do find musical pieces, dancing. These are performance or recitations of a literary work. Sport events, right, however, may not be recognized as dramatic work under this act. Now, is ice skating and gymnastic events, are they dramatic works? I have been to figure skating events at the Winter Olympics. I watched the gymnastic events in some Olympics. Could they be considered as dramatic works? Now, athletic events are competitive, therefore have no underlying scripts. And I could only cite a US case that is associated with the National Basketball Association against Motorola, right? Because such events are not recognized under US law. And definitely it's not recognized under English law as well. So these are copyright issues in sports events. Slide number 17, please. Now, copyright issues in sports events. The literary works, whether it's written, spoken, or part of a singing event, can be news articles and publications, but there is a vast amount of original written materials generated about the sport, including sport analysis of upcoming competitions, the coaching methods, including the rules and regulation, match reports, newspapers, calendar of events, tables and compilations. Just imagine the rules and regulations and the match reports are literary works and also include computer programs. Now, the database of information in musical works, such as the tune to an event or the theme anthems, are considered literary works. And then you can, if there is infringement, you can start an action under IP law, intellectual property, under IP law, intellectual property. Now we go into slide number 18. Trademarks is an important component of IP law. Patents, trademarks, and copyrights. These are important elements of IP law. Now, trademarks in sports events. They are recognizable, register trademarks, and they do generate goodwill. Like right now, the grass court Wimbledon's competitions are going on now, right? You can see the tennis players wearing Lacoste, Nike, Adidas, etc., etc. These are trademarks, and they do generate goodwill, and they bring in substantial commercial revenue, including the programs around the use, they make use of by the sponsor and third parties. Now, why trademarks is important in sports event? Because a trademark denotes the nature and the origins of the goods and services. It has to be any sign capable of being represented ethically, which is capable of distinguishing goods and services. Can include words and personal names. Remember, words and personal names. Like, for example, the world famous golfer Tiger Woods. That is a Tiger Woods, for example. And that includes other famous national soccer player. Let's say in Brazil, where Diego comes from, Neymar, his name will have commercial value. Isn't that true, Diego? Neymar will have the value in the same, right?
100%, Professor. He even trademarked his name in Brazil. So you cannot use Neymar Jr. It's not only Neymar, Neymar Jr. That name is a trademark itself. So yes, it's protected under the law. You cannot use it freely.
And trademarks names of the athletes are actually even registered in some countries.
Yes.
Because infringement of it can cost millions. Good. Next, please. Licensing and merchandising. Right? There must be agreements that provide for the use of the identity, the name, the logo, whether it is Adidas or Nike or Lacoste, etc., the trademarks and colors of other properties belonging to a sports person. Now you cannot wear the national colors of a country, club, national or national sports body in relation to the brand or publicize specific goods, services not connected to their main business. So this is licensing and merchandising, and that includes a lot of things from tennis rackets to sports hats to items, golf sticks. So these are part of licensing and merchandising. Slide number 20, please. Now, the licensor of rights, what do they have? One, the parties include individual athletes, famous people, teams, especially in team events. Team events can be cricket, can be hockey. As all of you know, hockey and cricket are very popular in India, and India is a great sporting nation. The organizers of events and competitions, right now you have the cricket test games. The owners of the venues and sports governing bodies, they are can be the licensors of those rights. Now, such parties must have proprietary rights in their identities within the sports law. They must own them. The licensor may use services of a separate company known as the producer. That is an arrangement between a licensor and its producer, right? That we don't have to be focused about. So licensors of rights here I refer to intellectual property rights. Who are they? These are the parties. Next, please. Now let's talk about merchandising revenue. And actually, this is a worldwide survey conducted by Pricewaterhouse. Merchandising sales activities actually account for 14.5% of worldwide sports revenue. 14.5%. The sport market is expected to grow at compound annual rate of 3.7%. And the income from merchandising is around 2.6%. Isn't that very substantial? And this is based on a reliable source from Pricewaterhouse. It's a worldwide survey. Merchandising revenue, very substantial. Number 22, please. what is the objective? You have to bear with mind why there are more facts than law. Because I did say in my first lecture, sports law is 30% law, 70% facts. In the sports law, hearsay evidence is admissible. And also a cardinal principle you must remember. National courts do not, as a rule, interfere with the decisions of sports tribunal decisions. What is the objective? For the licensor, that must be one thing. They want to have a source of revenue. That is very clear. They want to have visibility. These are their key factors. Now, brand development is also an important factor for the licensor. Now, can link to inspirational aspects of lifestyle, like health and fitness. For example, 100 plus is a drinks, right? And that is supposed to be a drink to enhance nutritional value. Fitness can be associated with fitness centers, wellness centers, right? For the producer, his objective is definitely to get more money, the revenue, and to get market positioning. Right? You cannot let this to be dominated by another competitor. And also for his creations and maintenance of brand portfolio so that are in competitions with other producers to maintain his brand portfolio, to maintain its positions in the global market, because branding in sports is usually worldwide. Number 23, please. Now, there are definitely risk factors in licensing. Definitely. There are some inherent dangers. Why? By failure to capture the market, that can result in outright damage to the brand if the deal is not well structured. Can do more harm than good. And there is another risk factor, right? There may not be a guaranteed minimum royalty. The licensor has the right to terminate the agreement if target is not achieved. Can you just imagine? So this has to go around with how you draft the agreement. There must be a minimum income. Otherwise, the licensor has the right to terminate. If his financial revenue objective has not been reached. Next, please. Now we talk about the principal clauses in merchandising and licensing agreement. As all of you are potential sports potential lawyers, whether it is in India or in Hong Kong or in Singapore, you have one thing. As a future lawyer, there must be due diligence when you're dealing with the right party. DD report, very important. Then you have computer games with stimulations and competitions of the league to include all the participating clubs. Right? You cannot have a computer games. If there are 50 clubs, you only include 20 clubs. So you have to be very clear-minded and exercise due diligence. Now, the governing body of a particular sport also has the constitutional right to grant the right in respect of logos, branding on a collective basis for all the teams. Now, the organizers of a league game over a year, over a period of 6 months, they may have the legal right, the constitutional rights to enforce all participating countries, all participating clubs. They may have a logo, and it can be collective basis for all the participating teams. Next, please. Now we talk about the grants of rights. There are three major areas. It could be under territory, or it could be for a term, for a particular period of time, 1 year, 3 months, 3 years. We must know the nature, the scope. That is very important. For example, an agreement that the computer game is to be marketed in the DVD format within England. Then the products, cannot be sold in places outside England and in a different format. That will be an infringement of intellectual property rights, especially computer games played with, and usually computer games is played by a lot of youngsters in Asian countries. Now, if there is agreement that the game is to produce and to be limited within a certain country, then, and if it is subsequently marketed in the country next to it, then it will be an infringement, right? And this is a case when it specifically mentions that it is only to be used in England. And if it is used outside England, then it's a different situations altogether. Number 26, please. Now, the brand has commercial value. Branding is very important, whether it is Nike, Adidas, Lacoste, etc., etc. So the maintenance of the brand is of commercial value to the manufacturers and to the producer. Now, the licensor has to ensure that there is quality and value of his brand. It must not be compromised. There must be quality. And then the producer only sell products and services approved by the licensor in all aspects, right? The licensor must ensure that his distributors and his producers will only sell products, activities associated with the licensor. There must be careful usage of design, safety materials. Otherwise, the licensor can be sued for negligence and construction. So materials are very important. Must be of high quality, and the safety assurance must be guaranteed. Next, please. When you are a lawyer, whether it's a commercial lawyer or a sports lawyer, the next thing you have to consider, you have to talk about indemnities and liabilities, limitations, liabilities. Limitations, liabilities operate in certain branches of the law, right? Now, in sports law, you have to create it. Like in another branch of the law, let's say shipping law, you have the Hague rules and the Hague rules. The limitations, liability is part of international convention. But sports law, you have to create it. So the licensors should exclude consequential laws and economic laws. Now, then the producer will then have some kind of guarantee that the licensor has the IP rights, and there will be no infringement from any third parties. The licensors will have to take legal action for any breach by third parties and to indemnify they are authorized producer from any dealings with third parties. Any dealings with third parties. Number 28, please. As lawyer, you must understand warranties, undertakings. You must get, if you're representing the producer, you must extract undertakings from the licensor. What are they? You can extract warranty from the licensor on the issues of the ownerships and full control of the rights under the agreement. That's very important. The commercial consideration is fundamental, is important. There must be full authorization and there must be competence, legal competence even to enter into agreement. Right? So to make sure that if there are third parties' rights to be acquired, then it must be specifically mentioned in the undertakings and warranties. Right? Law of contracts and the law you learn about warranty. Next, please. Now, producers must have their own warranties as well. Producers must have their own warranties and undertakings. Now, licensor requires a warranty from the producer. Why? As to the nature and quality of its designs. That is very important. Right? And can also enforce on the producer to take actions against pirating too. Piratings of sportswear, sports shoes are rampant activities in several Asian countries. Now, the manufacture and the material used must be of high quality. The material used must be of high quality. Then also important things like quality of their services, qualification and quality of its advertising or promotional activities, materials are safe and up to relevant standards and in full compliance with the law and regulations. And also at the same time, there must be undertaking to protect the rights of minors. In other words, underage athletes. That's also a factor to be considered. Lastly, we have slide number 30. Now we talk about alcohol, gambling, and fast food. In fact, there is a lot of materials, facts on alcohol, gambling, and fast food. Strange enough, alcohol advertisement is prohibited to protect lifestyle, to protect health standards. However, but Heineken's beer is part of the Heineken Cup, and Johnny Walker, which is whiskey, is an important sponsor of Formula One. Although alcohol advertisement is prohibited, but then Johnny Walker, very famous whiskey, and can slip in to take sponsorships of Formula One. Now, gambling, snooker competitions sponsored by betting and gambling companies. There is an element of criminality. Gambling companies should not sponsor such snooker competitions in order to promote gambling, especially in football fields or even in snooker. Now, how about fast food sponsorships at Olympics, like Coke and McDonald, they are sponsors at the Olympics, right? These, whether it's alcohol, gambling, or fast food, the important consideration is protections of underage children and vulnerable groups. Vulnerable groups. This is a key legal factor. Now, with this, I conclude lecture 7 of my sport law course in India, sports law course. And at the conclusions of lecture 10, I'm going to list out topics I have been advised by the university that I can give academic grades to my participating students in lieu of a written exam. So I'm going to give 10 topics for you to select for your written assignment. I will let you know the number of words and the deadline, and academic grades will be given. With this, I conclude lecture 7 on intellectual properties associating with sports law. Now we have time for 2 questions. I know someone is very eager to ask me questions on ambush laws. Please carry on. I think it's a very interesting point. Could you give me a written, summary of what you have said in less than 100 words? I will look into it and I will give you my commentary on this case at the next lecture. Okay?
Yes, sir.
Okay, so things like telephone booths, like stadiums, like I think on zones at the London Olympics, they have to cover up the stadiums to make it a clean stadium. Okay? Give me a commentary in 100 words, all right?
Yes, sir, I will. Thank you.
Any questions from my team, Diego and Betty Ho?
Thank
We have
you,
time
Professor.
for. Very good. Now, I have time for just one more questions. Any questions from my participating students in India? No questions? Now we have 3 more lectures to go, right? There will be 3 more lectures. And then on the 29th of July, there will be a panel discussions by sports law experts, including someone from the Asian Games. The Asian Games has not been cancelled, but it will be postponed to next year, and India is definitely taking part in the Asian Games. So we have 3 more lectures plus a panel discussions on the 29th of July. No questions? Okay. If there are no questions, I thank everyone for attending today's lecture. Next Tuesday will be lecture 8. Thank you very much, ladies and gentlemen. Thank you so much.
Thank you, Professor.